Okay, team, we're going to look at mitigation now. Mitigation operates a little bit different to the other ones in that it is about, I use the term quasi-duty that the plaintiff has to prevent some of the loss to the defendant. Why would the plaintiff have to avert some of the defendant's loss? This really goes back to this idea that contract law is about the efficient allocation of resources. Two parties come together, they form a contract, and hopefully they discharge their obligations by doing what they said they're going to do. But in situations where one or both sides don't do that, and one side's seeking compensation from the other one, it would be really inefficient if you made people turn up on the day and do and operate wastefully, knowing that they were going to be able to sue and get compensation. The courts, for a matter of public policy, don't want to encourage waste. And if you think about it, when you get the right to terminate a contract, some people might just want to turn up to court. Say, all right, cool, I've got these ice creams. I was going to deliver to them, you're on the Strand. You called me up to say you're going to be breached. Cool, that's fine. I'll just dump them on the side of the road. All right. No one wins from this. Sure, you would get to go and sue the person for non-acceptance. And sure, the principle of Robinson and Harmon, they need to put you in the position you would have been if they did what they said they were going to do, accept the goods and pay you. But the courts have said for a long time that is not a really good way of ordering our society. So to discourage waste, they've come up with a system, or a few rules, to really try and encourage people to try and reduce the amount of waste that's happening here. Now, sometimes you'll see this thing expressed as a duty to mitigate. It's not strictly speaking a duty. All it is a system for the defendant to reduce the amount they have to pay by essentially pointing at the plaintiff for trial and saying they could have done this better. Yes, we were in breach, but you could have taken some steps to reduce the amount of loss that I now have to pay for. And the courts accept this. And there's a wall of text on the screen. I'm going to go through and break these down. But I think the Burns and Mann Automotive is a good example of this. This involved a truck driver. And the truck driver had a truck, what do you call it, prime mover, is that the right word? And he drove around, I think it was in Victoria. Might have been the ACT, but I think it was Victoria. And he drove around with his truck. And anyway, it had an engine. The engine needed to be reconditioned. And the people doing the reconditioning, they didn't do a very good job. Okay, and the truck as a result was very inefficient. Couldn't go interstate, wasn't in good enough condition to go interstate, and it was very efficient, much more expensive in terms of fuel. And he carried on using this truck, going around and driving it as a result. And this case actually went all the way to the High Court because the repair company turned around and said, well, you know, you should have gone and stopped driving. And the courts there said, well, no, that's not actually how this test works. Because what happened was, he couldn't go interstate, so he couldn't get into those contracts. Because it was more inefficient, he ended up losing money hand over fist. But the courts mapped out this test, and they essentially explained those three limbs from a series of English and early Australian cases. And that's to do with reasonable steps. So that the plaintiff must take reasonable steps to mitigate the loss of the defendant. It's not a very high bar, but they have to do something. If they don't take some reasonable steps, then their damage award's going to be reduced. Yeah, sure. Sure. So it goes like this. If you, the plaintiff, have won, the other side is in breach. And so here, with Man Automotive, they've done a shoddy job of reconditioning this engine, right? You have to take reasonable steps to mitigate their loss. If you don't, your damages are going to be reduced accordingly. Now, there's a few sub-rules and sub-sub-rules here, because these reasonable steps are often, I hate to say this word, commonsensical, and you don't have to take or pull out all of the stops. What you need to do as the plaintiff is to take practical steps for doing things. Like in the case of my ice cream example, if I'm selling you the ice creams, you call me up and say, I can't accept the ice creams. What would I be able to do? Sell them off cheap. I don't have to sell them for retail. I just have to take some reasonable steps to mitigate your loss. I do not have to sell them at market rate, but I can't just dump them on the side of the road. And so I always find that example to be kind of interesting, because there are this is actually a scam in New Zealand, where people would have an ice cream truck, drive to a beach and go, oh no, my truck's broken down, and then try and sell, oh, would you take $5 for this? Whereas really they were just trying to sell a box of ice cream for $5. It's quite clever, really. Oh yeah, you take this box, you take that box, you take this box. Brilliant, brilliant strategy. But there's a couple of things to note here. It's a very low bar. Reasonable steps to mitigate the loss. Yes. No. Giving them ice creams, the example there is giving ice creams away for free. No, that's not going to mitigate the loss. No money's coming through. The idea is, and this is actually best illustrated by this one here, is that this idea of avoided and avoidable loss. If you could have avoided some of the loss and you don't, that's the amount your damages are going to be reduced by. And this case has some actually pretty unusual facts, in that it was the Underground Railway Company, so the one that runs the UK underground system, and Westinghouse supplied them with some turbines. And the turbines were really inefficient, really, really inefficient. So they were in breach. And so they took these turbines out and they bought some from another company, and then went to sue the original one for the difference. Trouble was, the new ones were so much better that they saved a huge amount of money as a result. Yeah, yes, this is an unusual set of facts. And kind of unfortunately, when this went to the House of Lords, the Lord said, look, you actually can't recover. You do have to take reasonable steps to mitigate the loss. And sometimes, some very rare times, you're actually going to mitigate the defendant's loss in entirety. Because the steps you took to mitigate this, and again, going back to the ice cream example, if I happened to rock up and I'm taking reasonable steps to sell these things, and it turns out this container ship of Korean tourists have arrived that love ice cream, particular flavors that I was going to sell you, Stacey, and I was able to sell those boxes that I was going to sell to you for $10, and I'm selling them for $20, I've mitigated your loss, more than mitigated it. And that's actually going to reduce the amount of damages that I can seek from you. Seems a little bit unintuitive. Only nominal damages if you still want to sue. So if I was still going to sue you, I know, it's unintuitive, eh? That's why this is an unusual situation. Don't get me wrong, Steve points this out. There's a reason why this case is from 1912. There aren't many cases after this. Why? Because cases like that don't come to court. Because if the parties somehow have mitigated this, and Stacey, you're a good example of this next example I'm about to give, which is residential tenancies. If there is a residential tenancy and you breach it, right, I'm breaking lease and I've still got 4 months to go on my lease. What do you as the real estates do? What are you supposed to do? Okay. What they're supposed to do is to re-advertise and try to get somebody else to do it. You as the plaintiff, as the defendant, me as the person who's breaching, I could find someone else, whether the real estate accepts them or not. That's outside the scope of this subject. But if another person is found to fulfill that lease and they're paying more money, what happens to the original tenant? No, assuming that the real estate in a high demand, let's say Townsville after the floods, in that situation, if the real estate finds another tenant, or another tenant knocks on the door, or you as the defendant who's breaking the lease have found another tenant who's willing to pay more.
So you're saying like they're letting the tenant off the lease because they're like, cool, we got someone else that wants to come in and pay like double what you're paying.
Yeah.
So then therefore okay.
Yeah, strictly speaking, the tenant is still in breach of contract. Contract was to go for another 4 months. Strictly speaking, you can sue, and again, leaving aside the RTRA statutory framework, strictly speaking, you can sue for this 4 months the tenant has. But you have to take reasonable steps to mitigate that. Reasonable steps for real estates is to go and seek alternative tenants, which I'm not sure if I've got a case on it here. I think it might be a case a bit later on in the slides. And so the idea of going and seeking alternative tenants, if you find a tenant who's willing to pay more money, what is your loss? There's no loss. And so that's why, again, these are unintuitive rules, because it seems strange. It can be, and sure, the time that it's vacant, you can still seek compensation for that. And the cost of advertising goes to towards the tenant as well for going through and doing that. But assuming that if the tenant, for example, says, I wish to break this contract, I'm mitigating your loss by finding another tenant willing to pay more. What's your loss? Sure, there might be an administration fee, but if the tenant's paying more money, even that, arguably, is going to mitigate your loss. And the reason why they have these rules is because we want people to solve their own problems without going to court. That's how and where these things sit. So while this Westinghouse Electric case is very unusual, it is. These sort of things don't end up going to court because people solve their own problems sometimes, pretty rarely. Okay, the taking of reasonable steps. So going back to Burns and Mann Automotive, taking reasonable steps by carrying on driving the truck, because we appreciate if somebody's made a mistake on your engine and they've mucked it up, you could either stop driving or you could carry on driving. All right, going back to Hadley and Baxendale, if you stop the mill, very expensive. And in a situation where you could carry on driving, making not as much money, that is the series of reasonable steps that you ought to take. And so there, the trouble is, sometimes you're going to take reasonable steps, which is what's happened in Burns and Mann Automotive, and those reasonable steps are going to lead you to suffer more loss. Can you claim that from the defendant? Yes. Yes, you can. Sometimes me selling this ice cream super cheap might give it, what's an example? Giving the ice cream to somebody who then faints. Okay, yeah, that's a good example actually. Jordan said, came up with the wage of the person who's selling ice creams. And so if it's my employee going and delivering Stacey these ice creams, and the cost of me having an employee or two to go and sell these things at $20 an hour, whatever they're being paid, the amount of that wage might not be covered by the bulk ice cream reduction that I'm doing and selling these things. And again, as long as I can prove to the court that these steps are reasonable, I'm going to be fine, even if I lose a little bit more money. I'm going to be able to claim that from Stacey in that situation. This idea of loss that can be avoided, it's enshrined in the Sale of Goods Act for when you're selling goods as well. So this is this idea of avoidable loss. The Sale of Goods Act, by the way, I think I've brought it up. For some reason, we don't do it as a separate module in Contract B these days, but it pops up from time to time in certain sections. If you do commercial law, which was mandatory up until quite recently, you do the Sale of Goods Act in entirety, but these days that's an elective. So this is possibly in your law degree the only time this will come up. Be warned, the Sale of Goods Act is overridable. The Australian consumer law is not. That's why, sure, we can learn these rules. These are the default rules, but all of them can be changed. Absolutely. So overridable by express terms in a contract. But you'll see these phrases here. For example, measure of damages is the estimated loss directly and naturally resulting in the ordinary course of events. Sounds familiar. There they talk about available markets. One of the differences and distinctions between Stacey's example with the real estate is that there's one house. Okay? Actually works differently if I have an arbitrary number of goods, cars, whatever, that I could sell in a particular situation. Why? Because if you breach the contract and don't buy my car, the fact that I can sell it to someone else is utterly irrelevant. I could have any number of cars. What I've lost from you is the bargain. And me on selling the same car in a situation where I can obtain an arbitrary number of these objects from my supplier means that on selling the car is meaningless. It's meaningless. I can still seek compensation from the loss of the sale that's out there. Whereas if there was only one car, me going and on selling it to someone else, or in the case of Stacey's situation, if there's only one house, me going and on selling that to somebody else is important. And the amount that I get from on selling it matters. Does that make sense? That particular term, again, it doesn't really form part of this subject. It's more for commercial law, but it's a key thing to note when they use the term in the Sale of Goods Act, an available market for doing that. Okay, on to the next one. The next slide talks about avoided loss, which is, again, going back to that Westinghouse electric case. If you have avoided your loss, if Stacey has actually been able to go and get another tenant, particularly if it's a tenant that pays more money, there's no loss. The loss has been avoided. No damages can be awarded for that component. You can still get nominal damages though. If you do want to rock up to court, you can get your $20 or your $100. Okay, and this is this idea of taking reasonable steps. I've probably repeated myself a little here. That you can take reasonable steps to avoid your loss, and if those reasonable steps lead to you suffering a greater loss, you can seek that greater loss from the defendant. You are allowed to go through in common law and do that. Steps you have to prove as the plaintiff, the steps that you took were reasonable, and that you've now suffered more loss as a result. It's a dangerous game to play, of course. And that's why this idea of continuing to trade can be difficult. It can be a very, very difficult thing. And Simonius Vischer and Holden Thompson was an example of that, when there was a negligent audit. They carried on trading. The steps have to be reasonable. If they're not reasonable and you carry on trading, you can't claim that loss. Okay. The plaintiff needs to prove the causation aspect. They need to prove that a particular sum of loss was caused by the defendant's breach, and it's not too remote. So that's the first two components of this lecture. Here, though, there's actually an onus reversal. Every now and then in law, when we have these torts and in contract, you'll get in criminal law, you'll get an onus reversal where the other side bears the burden of going and proving these things. They need to actually rock up and prove that the plaintiff could have taken reasonable steps to avoid their loss. And again, these are two leasing cases. Some of them, again, involve evidence in a situation where the lessee breaches and the lessor doesn't take reasonable steps to get another tenant. They don't re-advertise, they don't do other things. They're not taking reasonable steps to avoid their loss. And as Stacey rightly pointed out, the reasonable steps can actually involve more cost. Re-advertising the tenancy. That cost is borne by the tenant in breach, usually. Should be. Okay. Anticipatory breach. Why am I talking about this? Because the mitigation component can't, by definition, start happening until there's some form of termination. Right? This is where anticipatory breach, or there's some form of repudiation. Typo. Boo. And if you don't accept that there's some form of breach, if you leave a contract on foot, you can't use these rules. You're not obliged to go through and do these things until this is actually crystallized. You need to actually have this breach before the mitigation starts to happen. Well, you need to go through and do that. Anticipatory breach, remember, is that idea the other side looks like they're about to breach, but the time of performance hasn't happened. All right, so that you have to have essentially repudiation ahead of the time of performance before you enter into this phase where you're required to do the mitigation. It just doesn't work in terms of time, because if there is an anticipatory breach, hey, look, it looks like they're about to do a breach. If we're happy with them to carry on doing that, the idea of needing to mitigate loss doesn't make any sense, because if we're leaving that on foot, we still have to then wait until they've actually done an actual breach, and the right for us to obtain damages actually crystallizes. The other side can look like they're going to not be able to meet the performance that they're promised as much as they like. Because you don't get a right to damages until that happens, unless you accept the repudiation, terminate, seek damages at that point. Right, and that that's the last of those three. They take a little bit of time to get your head around. There's three components, what we call broadly the damage reduction, or the damage reduction component of contract law. They're three quite distinct concepts. Causation and remoteness are kind of tied together, but they do require you to spend just a little bit of time engaging with it to really just get your head around how each of these fits in terms of the system of contract law itself, because you will have to know it, sadly, and they all tie back to dollars, and they tie back to a lot of the self-help remedies, things that people can go and do now. This knowledge is knowledge you have now, and going out and doing things in business and knowing and understanding how these things fit together in terms of taking steps. Because these steps, often these things don't end up in court. You go and you take the steps, you do the mitigation, and it reduces the amount that's payable. That is the common law. So I do recommend with this, it's a little bit harder conceptually than last week, particularly test for remoteness. I do recommend to go off and revise that a bit, and I very much recommend to read multiple sources. If you can, read your primary textbook and see if you can read one of the other textbooks, particularly Steve Crawl's book where he goes through and talks about this with a little bit more clarity. But anyway, team, much appreciated. I'm going to end the recording there, and I hope see you next week.